Hi everyone, Harry here to talk about a new case from the D.C. Circuit which may play out in the U.S. Supreme Court with broad implications for the January 6 defendants. All right, the defendant here is a guy named Couy Griffin, and he was convicted of criminal trespass and in particular knowingly entering or remaining in any restricted buildings or grounds without lawful authority to do so. And what that means is there's restricted area, including the White House, the Vice President's residence, where a Secret Service protectee is or will be temporarily visiting. So the president comes and has a meeting in in an embassy or a restaurant or wherever, that Secret Service now protect that, and you can't knowingly trespass. But this guy says, well, look, I knew I was trespassing on the Capitol grounds and joining the party, as it were, but I didn't know that Pence was in there, and you can't convict me of knowingly entering or remaining in any restricted building or grounds without lawful authority to do so. So he's convicted at trial, but he preserves this claim and brings it up on appeal. And what happened here really is fairly similar to what happened in the Fisher case, because we now have a 2-to-1 opinion authored by Judge Nina Pillard, who's on the left in the D.C. Circuit, with a dissent by Greg Katsas, the same conservative Trump appointee who dissented in the Fisher case and whose position in Fisher the conservative Supreme Court ultimately adopted. So the majority says, look, this trespass law is in order to boost security for Secret Service protectees. If you had to prove that you actually knew of the presence in there, it would impair the ability to protect the charges. And so they write, the government was not required to prove that Griffin was aware that Pence was the reason the grounds remained restricted. They were restricted, and a person trespassing on grounds he knows are restricted, which he did know, it said, very clearly, where he knows he lacks permission to be, may be convicted of a federal misdemeanor trespass, even if he doesn't know that a Secret Service protectee is within. So knowingly goes to knowledge of restriction, and the Secret Service protectee is just a fact that makes it restricted, but not part and parcel of what the person has to know. Okay, so now Greg Katsas says in dissent, this is going too far, and we have a series of hypotheticals of what seems like absurd results. So a Secret Service protectee is there, and it says restricted, but somebody cuts across the grass because they want to get home sooner. Or there's a wedding and it's at a hotel, and the president is present, and you don't know it, but you're a guest of the hotel, and you just go in a little bit on your way around the lobby. Now normally, so this kind of battle over far-fetched scenarios, it's a pretty familiar terrain for the cases that the Supreme Court has taken in recent years. Well, wait a second, the guy who's just cutting a corner of the grass, is he knowingly trespassing? Now, typically, a U.S. attorney who would get that case would never prosecute it for that reason. But the current Supreme Court, anyway, is enamored of using those far-fetched, or you could say absurd scenarios to say that this is not what the statute could mean. So in the Fisher case, they said, you really have to, it was a very sort of fine-grained statutory interpretation dispute, as is this one, if you read carefully the fine print between what Katsas is saying and what Pillard is saying in the majority. But this could well be replayed up at the Supreme Court. Katsas's kinds of hypotheticals, that's the sort of stuff that the Supreme Court was wrestling with when they decided the Fisher case. What about this or what about that? Just trapping normal First Amendment activity. And the Supreme Court said for that reason, not even so much a congressional interpretation, but really their own basis of what just goes too far, not exactly the Supreme Court's standard job description, because you could really ensnare benign conduct. You strike the law down. So it's fits the model here. And even though this guy is, definitely part of the reason we need extra protection for a Secret Service protectee, in this case, Pence, when marauders are going and people are calling for his head, you could see this replaying out in court in the sort of rarefied appellate discussion of, well, what about the guy cutting a few feet on their way home, etc. So that's what's set up for the Supreme Court. It will definitely get their focus and attention that Katsas has dissented. It will get it in the same way it did in Fisher. There will certainly be some support for taking the case and reversing, but whether it will reach Fisher is too soon to tell. If they do take the case, the betting odds then would be that they're taking it to reverse and endorse the Katsas view as they did in the Fisher case. So we will stay tuned for that. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.